Good evening. Once again, you're listening to the Hour of the Time. I'm William Cooper.
And I'm Carolyn Nelson.
Things are happening all over the place quicker than we can keep up with them, ladies and gentlemen. As of May the 16th, you're going to find most of the forest land and what they call federal land, which is also public land across this country, will be closed to usage by just about anyone. Pay close attention to what I'm going to read you. This is from the Federal Register, Volume 59, Number 32, Wednesday, February 16th, 1994. That's the Federal Register, Volume 59, Number 32, Wednesday, February 16th, 1994. Now bear in mind that this was open for public comment until April the 18th, 1994, and then it was extended until May the 18th, 1994. I believe it was May the 18th. And this was never publicized. No one knew anything about it. You just barely have time to get your 2 cents in, and you better overnight it. You better call. You better raise holy hell with your senators and your congressmen, and with the Chief, Forest Service, USDA, Post Office Box 96090, Washington, D.C., 20090-6090. That's the Chief, Forest Service, USDA, Post Office Box 96090, Washington, D.C., 20090-6090. Summary: this proposed rule would provide a comprehensive revision of the acts prohibited on the National Forest System enforced by personnel of the Forest Service, respond to emerging law enforcement issues, the enactment of new laws, using crime as a guise to bring in a police state on all federal land. Ladies and gentlemen, remember in my book, I outlined in Public Law 100-690 how forest rangers and postal officials were then authorized to be armed and act as part of the federal police, the coming state police of the New World Order. April 18th, 1994, comments must be received in writing by April 18th, 1994, extended to May 18th, 1994. But make sure you have your comments in before May 16th, 1994. Understand that, folks. Anything you get in on the 18th will be ignored, I guarantee you. Office of the Director, Fiscal and Public Safety Staff, Room 605, 1621 North Kent Street, Arlington, Virginia, during regular business hours, 8 a.m. to 4:30 p.m. Monday through Friday. That's where you can inspect comments received on this proposed rule. In the Office of the Director, Fiscal and Public Safety Staff, Room 605, 1621 North Kent Street, Arlington, Virginia, during regular business hours, 8 a.m. to 4:30 p.m. Monday through Friday. For further information, contact Jack Gregory, Law Enforcement and Investigative Staff. Phone number, area code 912-267-2471. That's 912-267-2471. Or Catherine Toffanetti, Office of the General Counsel of Natural Resources Division. Area code 202-720-2651. That's area code 202-720-2651. And I'm just going to go through and read high points. I'm not going to read the whole thing. Remember, this is from the Federal Register, Volume 59, number 32, Wednesday, February 16th, 1994. It begins on page 7880. Violators of these rules can be punished by imprisonment for a term not to exceed 6 months and are subject to a range of fines as a result of the enactment of the Comprehensive Crime Control Act of 1984. 18 U.S.C. 3559 and 3571. Both federal and state laws apply to the National Forest. 16 U.S.C. 480, that is, both federal and state criminal and civil jurisdiction apply to persons within the National Forest. During the past several years, however, it has become evident that reimbursement through the Cooperative Law Enforcement Program cannot alone provide the level of protection that should be afforded the public in Forest Service recreation areas. I didn't know there was a great outbreak of terrible crime in the forest. Did you, folks? When state and local law enforcement units cannot respond promptly and trained and equipped forest officers are at a location where persons need help or encounter criminal activity affecting those persons, the Forest Service should be in a position to render emergency assistance because forest officers generally cannot enforce state laws. The agency needs rules which will make certain state crimes violations of Forest Service regulations. Hope you understand what you're hearing. 18 U.S.C. 3559, 3571 and the National Forest System Drug Control Act of 1986 as amended. 16 U.S.C. 559B through G. Did you know that there was a National Forest System Drug Control Act of 1986? Subpart B grants authority to regional foresters and forest supervisors to issue orders and regulations prohibiting certain acts in specific areas. The term alcoholic beverages would be added to clarify which beverages are intended to be covered in the prohibition against possession and use of alcoholic beverages at 36 CFR 261.58. Prohibit possession of all forms of alcoholic beverages when provided by an order. In the present rules can be remedied by defining alcoholic beverages as beer, wine, distilled spirits, and any other beverage defined as such by state laws. A new paragraph is proposed to support on-site control of the public and maintain order during firefighting, law enforcement, or, the catch-all phrase, other operations. Prohibits offensive, derisive, or annoying communication. Just what in the hell does that mean, folks? Prohibits offensive, derisive, or annoying communications. Does that mean if you snore, they can kick you out of the forest? After I get through here, you won't have to worry about it because according to these rules, you're not going to get one toe in the forest, folks. The risk of public alarm, nuisance, jeopardy, or violence. Other actions directed toward inciting or producing imminent lawless action. Imminent lawless action. Can they now read your mind? This is amazing. Make arrests under that act. The National Forest System Drug Control Act of 1986. Prohibit the possession of contraband. What is contraband? Well, folks, contraband is anything they say it is. Certain animal parts are unregistered automatic weapons. Some samples of included items would be certain animal parts are unregistered automatic weapons. A new paragraph would be added prohibiting being under the influence of any controlled substance or alcoholic beverage. And here's one, fire. Prohibits the firing of tracer or incendiary ammunition. The wording of the paragraph requires that a forest officer must prove that a person actually fired the ammunition. Expanded to prohibit the possession of tracer or incendiary ammunition as well. The possession of tracer or incendiary ammunition on the National Forest System can be harmful to persons as well as resources and is clearly not within the public interest. If persons are prohibited from possessing such ammunition, there is less likelihood of it being fired. Fish and Wildlife prohibits the hunting, trapping, fishing, catching, molesting, killing, or having in possession any kind of wild animal, birds, or fish. Did you hear that? Paragraph A, currently prohibits the hunting, trapping, fishing, catching, molesting, killing, or having in possession any kind of wild animal, bird, or fish. Expanded to include the words transporting, buying, selling, bartering, or offering to buy wild animals, birds, or fish to cover additional activities. The revision would also add shellfish. Property administered by the Forest Service to clarify that the prohibition applied to United States government property rather than to the personal property of a forest visitor. That means all federal lands. By special use authorization contract approved plan of operations of federal law or regulation, the following are prohibited. To prohibit disturbing, damaging, excavating, digging, removing, transporting, possessing, buying, selling, bartering, or offering to buy, sell, or barter any natural feature or other property of the United States. That includes, folks, a pebble, a flower, a piece of grass, dirt on your shoes. The paragraph would also include a corollary addition of the disturbing, damaging, excavating, digging, removing, transporting, possessing, buying, selling, bartering, or offering to buy, sell, or barter any plant that is classified as a threatened, endangered, or sensitive species, rare and unique with the term sensitive in order to reflect a change in agency terminology. Sensitive, folks, means anything. Doesn't mean endangered. It just means sensitive. Occupancy and use of the National Forest System by persons or entities other than the Forest Service. The prohibitions in this section relate to occupancy and use of the National Forest System by persons or entities other than the Forest Service. Paragraph B would be revised for clarity to include residing upon the National Forest System as a prohibited act. If you have leased a cabin on forest land for a period of 99 years and you just leased it last year, your lease is up. Paragraph B would be revised for clarity to include residing upon the National Forest System as a prohibited act. Paragraph D would be revised to remove the prohibition against the discharge of a firearm across or on a forest development road unless any person or property is exposed to injury or damage. Forest Development Road includes closed roads, traffic service, level D roads, and other similar roads that have little or no vehicular use. Because of the limited traffic, hunting along these roads is not considered to be a safety problem. The proposed revision would add a prohibition against the discharge of a firearm from a vehicle and then make it clear that the current prohibition against discharging a firearm in any manner or place whereby any person or property is exposed to injury or damage as a result of such discharge or use applies to any location in the National Forest System. In other words, if there's even a slight remote chance that someone may be somewhere in the forest, you are prohibited from firing or using any firearm. A new paragraph would prohibit outfitting or guiding on the National Forest System without a special use authorization or in violation of federal or state law. Outfitting and guiding be conducted under special use authorization due to the lack of a definition for the two activities. The approach taken in the proposed rule is to define outfitting and guiding at 36 CFR 261.2 and then to prohibit these activities without a special use authorization at 36 CFR 261.10. In other words, there's another license you got to get. A new paragraph G would require the use of seat belts. Seat belts. If you're in the forest, folks, you must have a seat belt. A single rule that would apply throughout the National Forest System. This provision will ensure the protection afforded by seat belts throughout the National Forest System regardless of individual state laws. Prohibitions in areas designated by order. This subpart grants authority to regional foresters and forest supervisors to issue orders and regulations prohibiting acts in specific areas. In other words, they can make their own laws. Orders, Subpart A, Paragraph E1 would be revised to include the words special use authorization, contract, approved plan of operation, and federal law or regulation as the list of either authorizing documents used by the Forest Service, or to make clear that the order may also exempt persons with authorization given by law or regulation, which means no matter what the authorization is that you have, they can negate it. They can tell you no. Paragraph M allows for the issuance of an order to prohibit the discharge of a firearm, air rifle, or gas gun. Under the proposed rule, this paragraph would be revised to read, discharging or possessing a firearm, air rifle, gas gun, or other device capable of causing injury to persons or wildlife, or capable of causing property damage. For example, the addition of the prohibition against possessing is necessary for wildlife protection at certain times of the year on different national forest units and for public safety in areas of higher visitor use, or when property would be easily damaged by firearms and other devices shooting projectiles. The addition of any other device is necessary to support the inclusion of devices such as starter pistols, crossbows, which can cause serious bodily harm or death if used. And finally, the addition of capable of causing injury to persons or wildlife, or capable of causing property damage, is necessary to specify more precisely the type of device to which the prohibition would apply. In other words, you can't take nothing in the forest that you could use to hunt or fish or trap, period. And not just the forest. Remember, this applies to all public and federal land under the supervision of the United States government. Paragraph B would adopt the new definition of alcoholic beverage proposed, prohibit the storage of personal property in any area outside of a national forest developed recreation site when prohibited by an order. A new paragraph would be added to enable a regional forester or forest supervisor to issue an order prohibiting the possession, storage, or use of glass, food, or beverage containers. Now, you can't take a Coke bottle in there, folks. You can't buy a Coke bottle in there. You can't have any kind of a glass storage or glass food or beverage container. A new definition section would be added to provide for definitions of law enforcement officer and special agent. The definitions are needed in the regulation to support the section on purchase of evidence. Purchase of evidence. I didn't know that they purchased evidence. When did they start buying evidence, and what in the hell are they talking about here? Because it's not clear at all. But they're talking about purchase of evidence. Be revised and combined with Section 262.3, which governs the purchase of evidence. This revision is proposed in response to requests of several Forest Service regions for a payment scale for purchase of information and evidence that reflects the gravity of the offenses investigated, such as violations of the National Forest System Drug Control Act of 1986, as amended, for example, amounts that special agents could be authorized to pay for information or evidence would be raised from $200 to $400 respectively to $500 for a single transaction, with other increase or changes proposed for the employees so listed. The agency's authority to make payments for evidence and information was affirmed in a decision of the Comptroller General dated April 29, 1971, and allows for payment to further any criminal investigation, notwithstanding the classification of the offense. In other words, you're sitting in your campground minding your own business, and the two scumbags in the campground next to you run out of money. What do you think's going to happen now? Why, they're going to go sell some evidence against you to the forest rangers, just like they're already doing across this country. And what do you think's going to happen when somebody gets caught committing a crime? To turn state's evidence and get paid and get let off the hook, all they got to do is say, you did it, and testify against you in court. The title of this subpart would be Revised to read Administrative Impoundments and Removals, administrative remedies that may be taken by the Forest Service to impound and remove animals or personal property on the National Forest System. Criminal law enforcement procedures associated with impoundments and property seizures made pursuant to arrests and searches are not covered by the regulations and are contained in the Federal Rules of Criminal Procedure for the United States District Courts and the Forest Service Law Enforcement Handbook. In other words, they can take your property, your car, your rifle, your sleeping bags, your tent. And if it's anything like what they're doing in the rest of the nation, probably your children and your home and your RV and your land and your bank accounts. Paragraph D would be revised to allow the Forest Service to use unredeemed or abandoned personal property if it is needed for official use rather than having to offer it for sale. Which means if there's some forest agents who like something that you have, folks, and they don't have it, but they want it, they can just confiscate it from you, say that you were committing a crime, not press any charges, not go to court, no ruling by any judge, and the property is theirs to use as they wish. Remember Gordon Call? They wanted his land, so they went in and killed him. When are you going to wake up, sheeple? This is what they did in the Soviet Union. And we said that it could never happen here. Remember that? Removal of obstructions. This section currently provides for the removal of vehicles or other objects which create either an impediment or hazard to the safety, convenience, or comfort of other users of the National Forest System. Who's going to be there using it? They've outlawed everything that you could possibly do in the forest. And I'm not done yet. Remove it. The rule would be revised to include a vehicle or other object which has been left in such a manner that it impairs or may result in the impairment of any area of the National Forest System or other areas under Forest Service control. Automobiles or other large objects left as junk in popular undeveloped recreation areas of the National Forest System. Who interprets what is junk? This doesn't specify how long it has to be there. It doesn't specify what condition it has to be in. What if you're driving a car that needs a paint job and you leave it somewhere overnight while you're hiking in the woods? Will it be there when you get back? Can you even hike in the woods? The Forest Service proposes to amend its rules governing prohibitions and law enforcement support activities in order to improve protection of public and their property. Update the rules to reflect expanded Forest Service law enforcement authority granted by statutory changes. Now Forest Service personnel are law enforcement personnel. Make technical corrections and revisions due to the passage of new laws and the promulgation of new rules in other parts of this chapter, and provide both the agency and United States Department of Justice increased flexibility in prosecution options for certain offenses. I wonder how long it will be before they also have a SWAT team and are wearing Kevlar vests and ski masks. What do you think? Executive Order 12-866, it looks like. And Executive Order 12-630 for the evaluation of risk and avoidance of unanticipated takings directs all agencies to evaluate whether certain proposed agency actions present a risk of effecting a taking of private property. Of the order exempts law enforcement actions from a requirement of the executive order. In other words, they're exempt. They don't have to worry about it. They just take it. This proposed action involves additions and technical and administrative changes to prohibitions of activities on or affecting National Forest System land and resources, visitors, and employees. Section 2A3. The Department actively seeks to promulgate regulations that promote economic growth, create jobs, are minimally burdensome, and are easy for the public to understand, use, or comply with. The department is committed to issuing regulations that maximize net benefits to society and minimize costs imposed by those regulations. This principle is articulated in President Bush's January 28, 1992 memorandum to agency heads and in Executive Orders 12-291 and 12-408. Get those and read them. You will be amazed. The department believes that public input from all interested persons can be invaluable in ensuring that the final regulatory product is minimally burdensome and maximally efficient. Well then, why didn't they tell anyone that they were going to do it? I wonder. Why didn't they let anyone know that they were doing this? Why wasn't it on the news? Why wasn't this put out in the newspapers? Why didn't they notify the public that they're doing these things? I could go on and on and on, and this is several pages more, folks, that outlaw literally anything that you could possibly think of doing in a forest or on government land. In other words, you better not go in the national forest or on government land or federal land or public lands ever again. In here, if you have cattle on grazing land, ladies and gentlemen, on public land, you're not going to have them there for long. Law enforcement officer means an employee of the Forest Service in other than the Criminal Investigative Series GS 1811, which means all Forest Service personnel are now law enforcement officers. The state police are here. And there will be more of this in future days, weeks, months, and years. Who is authorized by the Washington Office Director for Law Enforcement and Investigations to conduct investigations, make arrests with or without a warrant or process. Make arrests with or without a warrant or process. Make arrests with or without a warrant or process. Issue violation notices. What's a violation notice? Execute and serve search and arrest warrants. Carry firearms for law enforcement purposes and perform other duties as directed in connection with the enforcement or administration of all laws, rules, and regulations in which the Department of Agriculture, Forest Service is or may be a party of interest. The Forest Service, including the authority to conduct investigations, to execute and serve search and arrest warrants, to serve orders, subpoenas, or other judicial processes as directed, to carry firearms, make arrests, issue violation notices, and perform other duties as directed in connection with the enforcement or administration of all laws, rules, and regulations in which the Department of Agriculture, Forest Service is or may be a party of interest. Wake up, you stupid sheeple. Our country is gone. It has been gone for a long time. We are moving into the Soviet gulag quicker than you can wink. Where's the freedom? It's not reasonable, ladies and gentlemen, to assume that the citizens of the 13 colonies who had fought a revolutionary war to absolve themselves of the centralized power and jurisdiction of the English king would shortly thereafter cede a comparable power and jurisdiction to the federal government. It's not reasonable at all. The citizens established a nation, unique in all the world, free of governmental greed, power, interference, and restraint, a nation where happiness was a sacred right and where liberty, freedom, and independence were fundamental and unchangeable principles. What has happened? Webster defines freedom as, quote, liberation from the control of some other person or arbitrary power, liberty, independence, unquote. Webster defines independence I'm talking about what our forefathers collectively formed. The government, their servant, they, the sovereigns. The only purpose of government in the constitutional republic our founding fathers established was according to the Declaration of Independence, which most of you have never read, never paid much attention to, don't have a copy of, have no idea what it says. The only purpose of government in the constitutional republic was, according to the Declaration of Independence, quote, to protect the rights of the governed, unquote. What has happened? According to the Supreme Court, United States versus Lee, 106, U.S. U.S. stands for United States Supreme Court, 196 at 208, and I quote, under our system, the people who are there in England called subjects are here the sovereign. Their rights, whether collective or individual, are not bound to give way to a sentiment of loyalty to the person of a monarch. The citizen here knows no person, however near to those in power, or however powerful himself, to whom he need yield the rights which the law secures to him when it is well administered, unquote. Would you say that it is being well administered now? What has happened? I quote again. Here, sovereignty rests with the people, unquote. Chisholm versus Georgia. First Law Edition, 2 DALL 415, 472. Quote, the words people of the United States and citizens are synonymous terms and mean the same thing. They both describe the political body who, according to our republican institutions, form the sovereignty. They are what we familiarly call the sovereign people, and every citizen is one of this people and a constituent member of the sovereignty, unquote. Why is it that you never knew that? That's from Wong Kim, Arkansas, page 914, quoting Dred Scott versus Sandford, 60, U.S. Supreme Court ruling 393-19, HOW 577. Sovereigns, ladies and gentlemen, are entitled to all rights which formerly belonged to the King of England. Although titles of nobility are prohibited under the Constitution, the courts have ruled on several occasions that the people, as sovereigns, are entitled to all of the rights and prerogatives of a king. Quote, people of a state are entitled to all rights which formerly belonged to the king by his prerogative, unquote. Lansing versus Smith, 21, 1.89. The word prerogative, folks, means, and I quote, exclusive right, a distinctively superior advantage, unquote. This is another court ruling establishing we, the people, on an equal level with the king. Quote, it is true that at common law the duty of the Attorney General was to represent the king, he being the embodiment of the state, but under the democratic form of government now prevailing, the people are king. So the Attorney General's duties are to that sovereign rather than to the machinery of government, unquote. Hancock versus Terry Elkhorn Mining Company, Incorporated, Kentucky, 503 SW, 2nd, 710, Kentucky, Constitution, 84, Commonwealth. Hancock versus Paxton, Kentucky, 516 SW, 2nd, page 867, 2, clause 3. A sovereign is answerable only to God and conscience. The definition of sovereignty, this one, is from Bouvier's 14th edition Law Dictionary, quoting from 4 Wheat 402. Quote, "It has been justly thought a matter of importance to determine from what source the United States derives its authority. The question here proposed is whether our bond of union is a compact entered into by the states, or whether the Constitution is an organic law established by the people. To this we answer, we, the people, ordain and establish this Constitution. The government of the state had only delegated power from the people, and even if they had an inclination, they had no authority to transfer the authority of the sovereign people. The people, in their capacity as sovereigns, made and adopted the Constitution, and it binds the state governments without the state's consent. The United States as a whole, therefore, emanates from the people and not from the states. And the Constitution and the laws of the states, whether made before or since the adoption of that Constitution of the United States, are subordinate to the United States Constitution and the laws made in pursuance of it. The people are the fountain of sovereignty. The whole was originally with them as their own. The state governments are but trustees acting under a derived authority and had no power to delegate what is not delegated to them. But the people, as the original fountain, might take away what they have lent and entrust to whom they please. They have the whole title, and as absolute proprietors have the right of using or abusing. It is a maxim consecrated in public law as well as common sense and the necessity of the case that a sovereign is answerable for his acts only to his God and his own conscience. There is no authority above a sovereign to which an appeal can be made. The supremacy, ladies and gentlemen, sovereign dominion, authority, and preeminence, the highest state. In the United States, the supremacy resides in the people, unquote, Bouvier's Law Dictionary. It is the doctrine, ladies and gentlemen, of the common law that the sovereign cannot be sued in his own court without his consent. The Siren versus United States, 74, United States Supreme Court ruling 152. How come you don't know that? How come they're pulling the wool over our eyes on a daily basis? Why is it? What has happened? There is no power of inherent sovereignty in the government of the United States. There is no such thing as a power of inherent sovereignty in the government of the United States. There is no such thing. In this country, sovereignty resides in the people, and Congress can exercise no power which they have not by their Constitution entrusted to it, all else withheld. Juilliard versus Greenman, 110, United States Supreme Court decision, 421. Sovereignty itself is, of course, not subject to law, for it is the author and source of law. Yik Wo versus Hopkins and Wu Lee versus Hopkins 118, United States Supreme Court Decision 356. Quote, under our form of government, the legislature is not supreme. It is only one of the organs of that absolute sovereignty which resides in the whole body of the people. Like other bodies of the government, it can only exercise such powers as have been delegated to it, and when it steps beyond that boundary, its acts are utterly void. Billings versus Hall, 7 CA 1. Quote, in Europe, the executive is synonymous with the sovereign power of a state, where it is too commonly acquired by force or fraud, or both. In America, however, the case is widely different. Our government is founded upon compact. Sovereignty was and is in the people, unquote. Glass versus the Slope Betsy, 3rd Dial 6. The government of the United States that we, the sovereign people, created and entrusted to protect our fundamental rights has misled us, has deceived us, has lied to us into believing that the government is sovereign and we, the people, are persons subject to United States jurisdiction. Now what, I ask you, is their motivation for this mass deception, this manipulation, this great lie? The Supreme Court has ruled that the rights of sovereigns cannot be taxed or regulated by the government. In law, the person is generally a juristic or corporate entity without rights. A human person is called a natural person. By creating a legal term for person that excluded the sovereign, the government has been able to create vast volumes of governmental rules and regulations for the person to pay income tax, property tax, license and registration fees, business license fees, marriage license fees, dogs license fees, etc. It is also this person that the government can jail as an incentive to comply with its codes. The sovereign is not the legislative person, but they have convinced you that you are. The term person does not include the sovereign. Since in common usage the term person does not include the sovereign, statutes not employing the phrase are ordinarily construed to exclude it. United States versus Fox 94, United States Supreme Court Decision 315. The sovereignty of the state resides in the people thereof. California, Title I, Article 1, Section 100. Quote, while sovereign powers are delegated to the agencies of government, sovereignty itself remains with the people by whom and for whom all government exists and act. Yik Wo versus Hopkins and Wu Lee versus Hopkins 118, United States Supreme Court Decision 356. Quote, state governments are but trustees acting under a derived authority of the people, unquote. 4 Wheat 402. The Articles of Confederation, which were not repealed by the Constitution, did you know that, folks? The Articles of Confederation were not repealed by the Constitution. State this. Article 2. Each state retains its sovereignty, freedom, and independence, and every power, jurisdiction, and right which is not by this Confederation expressly delegated to the United States in Congress assembled, unquote. Quote, each state declared itself sovereign and independent according to the limits of its territory. The soil and sovereignty within their acknowledged limits were as much theirs at the Declaration of Independence as at this very hour, unquote. Harcourt versus Gilliard, 25, United States Supreme Court Decision, 12 Wheat, 523, 526, 527. The original several states were each separate, independent, and proud nations who vehemently valued their freedom. They fought and died in a revolutionary war to sever their ties as subjects of the King of England. As previously stated, their purpose was to establish their independence as sovereigns. The states jealously guarded their own sovereign rights, powers, jurisdiction, and land. Why is it that most of the land in most of the states, of the several states of the United States, is owned by the federal government? How did that happen? They haven't paid anyone for it. The states refused to cede their newly won sovereignty to a federal government and be subject to another jurisdiction. The citizens of the states, however, thought that it would be advantageous to the general welfare of the states to delegate certain responsibilities, such as uniform monetary creation, which was to be in gold and silver, defense and postal services to a federal government, other than the very limited and reclaimable cessions of powers delegated to the federal government as specified in the Constitution. The states maintained the same independent sovereignty that they had under the Articles of Confederation. The only concession of lands made within the states to the federal government were lands or enclaves essential for the operation of the federal government. Article 1, Section 8, Clause 17 of the Constitution gave the federal government exclusive sovereignty and jurisdiction over only the District of Columbia and the territories and possessions belonging to or ceded to the United States. A federal marshal on your private property within a sovereign state has no jurisdiction and no authority whatsoever. Neither does the BATF, neither does the Federal Bureau of Investigation, neither does the Post Office Department or the United States Forest Service, and public lands belong to we the people, not the federal government. Do you understand what I am conveying to you? However, you must understand in America, such federal jurisdiction could not exceed a 10-mile square outside of the District of Columbia and did not include the 50 states which retained their sovereignty through their people. Prior to the adoption of the federal Constitution, states possessed unlimited and unrestricted sovereignty and retained the same ever afterward. Upon entering the Union, they retained all their original power and sovereignty except such as was surrendered to the federal government or they were expressly prohibited from exercising by the United States Constitution. Now, listen very, very closely, for I'm going to outline for you the limited powers of the United States. This is a list of the only areas where the people have ceded powers to the federal government. Remember that absolute sovereignty is still with the people, and there can only be one sovereign. The Constitution for the United States of America, Article 1, Section 8. The Congress shall have the power, 1, to lay and collect taxes, duties, imposts, and excises with the following restrictions. A. All direct taxes must be apportioned, that is, divided equally according to population. And B. All indirect taxes must be uniform. Now I ask you, where does that leave the graduated Marxist income tax? 2. To establish uniform rules regarding the naturalization of aliens. 3. To establish uniform rules of bankruptcies throughout the United States. 4. To coin money. To coin money. To coin money. That meant gold and silver coin, and the law specifies that a dollar is 1/20 of 1 ounce of gold. To regulate the value of such money and the value of foreign coins, and to fix a standard of weights and measures for such money, which was done and has never been changed. What you have in your pocket is counterfeit debasement. 5, to provide for the punishment of counterfeiters of United States coins and securities, and the law says the punishment for the debasement of the monies of the United States of America is death. Yet I see no officers of the Federal Reserve hanging from any gallows, where they should be hanging at this moment. 6, to establish the post office and post roads. 7, to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings, in effect copyrights and discoveries or patents. 8, to constitute tribunals or courts inferior to the Supreme Court, to define and punish piracies and felonies committed on the high seas, to define and punish offenses against the law of nations, to declare war, to grant letters of marque, letters of retaliation and reprisal, to make rules for capturing the enemy on land and water, to raise and support armies, to appropriate money for the military. No appropriation of money for the military shall be longer than 2 years. Now understand what I'm telling you. For 15 is to provide and maintain a navy, and the navy is the only authorized standing military force that is constitutional. Number 16 is to regulate the land and naval forces. Number 17, to call forth the military to execute the laws of the Union and to suppress insurrections and repel invasions of the enemy. 18, to organize, arm, and discipline the military. The appointment of officers and training of the military as prescribed by Congress was reserved to the states. The states. Yet the appointment of officers and training of the military is not being done by the states, therefore guaranteeing their treason when they are ordered to move against the sovereign citizens to bring about the one world government. Other than these specifically delegated powers, the government of the United States has absolutely no power over the citizens of the 50 states, and you will notice, ladies and gentlemen, there is nothing here that gives them authorization or power to enforce the law anywhere. Anywhere. You see, the Constitution prohibits a police state. So, how is it that a police state is emerging nationwide? The United States government may not assume powers not specifically granted to it by the people. Also, the people, as the absolute sovereigns, may take back any powers it has delegated, and it is time for us to do that. I must warn you, though, there will be no political solution, there will be no relief in the courts. If we are to maintain our freedoms, if we are to reinstate the Constitution as the supreme law of the land, legally within the law, it will be by the means that our forefathers left for us, exercising our rights and powers guaranteed to us by the second article in Amendment, all power. As Mao Zedong once said, he did say something right, folks, all power emanates from the barrel of a gun, and the moment you give up your guns is the moment you cease to have any power in this entire world. Good night. Wake up, and God bless you all.
I can see clearly now the and see all obstacles in my way. Gone are the dark clouds that had me blind. It's gonna be a bright, sunshiny day. It's gonna be a bright, sunshiny day. I can make it now.
If you would like to learn the real, true law and regain your personal sovereignty, stand as a king in your own right. Send for Vultures and Eagles Clothing, $43, to P.O. Box 1420, Sholo, Arizona, 85901. That's Vultures and Eagles Clothing, Post Office Box 1420, Sholo, Arizona, 85901. Make your checks or money orders out to Annie, A-N-N-I-E, and address your letters to Caji, C-A-J-I. We also have another excellent book that will help you in your efforts to regain your status as a sovereign king in your own right. The name of that book is Goodbye April 15th. It also is $43. With Vultures and Eagles Clothing, you get the right with your purchase to resell the book and earn your money back by helping to educate others.